Recording. And we're live.
All right, Bob, it looks like a good portion of our pre-registered attendees have joined, so we'll get started. Hello, everyone. Welcome to today's joint program between the Mdtc and the American Board of Trial Advocates Michigan chapter on civility within the litigation process. As many of you know, my name is Brandon Shoemaker, and I'm the Young Lawyers Section co-chair for the Mdtc. And here today with me is Bob Riley. As a couple of reminders for everybody, before we get started with the program, there are two events coming up in the near future. The first one is the Mdtc Legal Excellence Awards on March 17th, 2022. It is the first in-person event of the year at the Gem Theater. And the next is the summer conference from June 16th to June 17th, titled What's New? A defense-specific discussion on there we go, screen froze. A defense-specific discussion on adapting to an ever-changing legal landscape that will also be in person at the Treetop Resort. And with those dates on your calendar, I'd now like to introduce our speaker, Bob Riley. Bob is a longtime attorney with over 40 years of experience. He has a long litigation history in trying cases of both a plaintiff's and defense attorney. He's also been involved in greater than 12 labor agreements in the professional hockey arena at all sorts of levels. He's also the Michigan chapter, involved with the Michigan chapter of the American Board of Trial Advocates, and he's the current chairman of the State Bar of Michigan Negligence Section. He's been involved in a number of different things over the years, and more recently, including court rule changes, and sat on the committee that proposed changes to the rules, as well as the mediator for the Anderson sexual assault cases against the University of Michigan. Bob has a wealth of knowledge he's here to share today. And with that, I'll turn it over to Bob.
Thank you, Brandon. And let me thank the two organizations that put together this kind of programming. I appreciate the efforts of the Mdtc to address an issue as important as we're discussing today. And of course, the American Board of Trial Advocates has its own series of programs entitled Civility Matters. Today is not going to be one of those programs. Instead, it's going to be directed to a much more conversational program designed to address concerns over civility in the profession. Let me at the outset tell you that we welcome questions. We're going to monitor the questions that come in. Please submit them. We'll try to reserve time to answer questions. Translate it, don't be bashful. Add questions to the mix, and we'll do the best we can to answer them. The genesis of this discussion today emanates from an evolving problem. And I'm going to begin with a confession. In my career, I have lost my temper. I have probably been the individual that someone would say, gosh, Bob, you could certainly be more professional and civil. I remember an incident in my career. The extenuating circumstances are irrelevant. I was wrong. I dropped a series of F-bombs at 2 a.m. during a session with my opposing counsel. And I felt so bad about it, I had to write an apology letter. I was truly embarrassed by my conduct, and I thought it essential to do that. And my opposing counsel, who I had little use for, frankly became my friend because of the apology note. It taught me an important lesson that I shouldn't have lost my temper or cool in the first place, but at least I took some corrective action to deal with it immediately. So as we begin today, please don't think I'm some know-it-all or a prima donna who knows how to behave and I'm lecturing people. That is absolutely not the case. As we digest civility in the current environment, please recognize that we have a compounding factor. It's one thing to talk about the pressures and the tension and the advocacy that turns into rough statements as a routine in our profession, but the pandemic has made it worse. In doing my work, I've noticed that we have shifted gears, that the collegial relationships that we had emerged from in-person and seeing our opponent or seeing the other side or seeing the courts, those collegial activities generated civility. It seems rare that people actually lose their cool when they're in person. It happens much less in my assessment. The problem, however, is that with remote work and the ability to sit behind a screen, we sometimes have boundaries that reflect poor behavior, that reflect remarks that never would have been made in person, that illustrate the worst of our profession in ways that many may never have intentioned, but felt they could get away with. We have an example that occurred in one jurisdiction where a lawyer gave the finger to a judge. I laughed about that because we've all had rulings that we didn't like. We've all faced situations where the judge's remarks may be counter to what we believe is necessary or appropriate. But the respect to the judiciary in person is taken for granted. But yet we had an attorney who, under whatever guise and whatever excuse and whatever explanation, suggested a measure of disrespect that is intolerable. And maybe not a good example because that's so dramatic and so clear cut. But as we live in this virtual age, we have lots of evidence. Video depositions are the routine. They're recorded. And the illustrations of civility and its disappearance in discovery activities is rampant everywhere. I see this in my role as a mediator because people submit transcripts to me as part of their summaries to explain their case. And while I should probably focus on the immediate issues of, say, proximate causation or damages or key liability features of the case, you can't help but notice what's occurring apart from the key testimony, but the colloquy between attorneys and each other. It's disrespectful, it's routinely problematic, and we're getting away from the kind of professionalism that's necessary and appropriate for the honorable work that we're called upon to do. So it is in that context that this program today emerges. And I'm going to ask you to think about civility in ways that you probably have never thought about it before. When I'm called upon to analyze questions, problems, or issues, I have a few techniques that I always fall back on. And I'm going to use those today as I talk with you. They're threefold. First, I always explore fundamental principles. What are the principles that should govern a particular question or setting, dispute, development of a case, whatever? The second question I look at is structurally, where does this fall? What kind of analytical infrastructure is important in analyzing problems? And the final thing I look at, my third point, is what is the application of principles and structures in real life? So let me start with my methodology for analyzing a host of issues. As I indicated, I start with principles. What are the principles that should govern a particular situation? Are principles at issue? Should they be at issue? And will they come into play? And the answer here is overwhelmingly clear. There are principles that should govern us. And I'm going to point you to three examples. First, the Michigan Supreme Court has recently issued professionalism guidelines. This is the first attempt by the court to define for those of us who practice law, and in particular trial lawyers, to have certain guiding principles, guideposts, advice. These guidelines enacted by the court are a useful and chronicled evidence of principles that lawyers should follow. There's a second example, and that's the Eastern District of Michigan in federal court. They have a set of detailed principles that are an issue. These guidelines are enforced in federal court from time to time. They're several pages in length. They're part of the local court rules. And I have seen instances in which the judiciary has actually enforced guidelines in the Eastern District. There's a third example. A similar and complementary set of guidelines exists in the Western District of Michigan in the federal courts. So they too have structured for the attorneys who practice in that forum a concrete set of principles that are applicable to the lawyers who file appearances and participate in litigation in that setting. Now, why do I reference these? Well, first, there can be no confusion. Apart from the rules of professional responsibility and the obligations we have when we take our oath, we have specific guidelines at both the state and federal court level that should govern our conduct and our deportment. They're important, and we are making arrangements so that when this presentation is concluded, those of you who have been part of this today will be receiving those three documents. It's not my purpose to go through them today, but it is my purpose to alert you to these important rules and limitations on attorney behavior so that you can see them firsthand. I'm going to make this observation, is that we have done a poor job, even with such guidelines, in enforcing civility and professionalism. There's a keen reluctance to address these issues. I'll give you an example. An attorney was listening to the defense attorney cross-examining a witness. And they got into a series of arguments about the legitimacy of the questions and the like. Objections are flying back and forth. The female defense attorney persisted in her arguments that the plaintiff was approaching things the wrong way, plaintiff's counsel. And plaintiff's counsel's retort was, thank God my client is blind because he can't see what a fat pig you are. Now that's baffling that we would ever denigrate each other at such a level. It is shocking and appalling that such an example even exists. But the individual involved was so shaken and upset that outright rejection of making any report of it, dealing with it, because of the overriding humiliation associated with such a dastardly comment. Again, an extreme example, but we have reached a point of tolerance that needs to be addressed at higher levels, that needs to become part of our culture, that we don't accept as routine lack of civility or professionalism. Now I could give countless examples, and I'm not here to tell war stories. That's not my purpose. My purpose is to illustrate two concepts with respect to principles. Apart from their existence, point number one is we need to have a principled core value as attorneys to honor civility and professionalism. It's essential. It's what we do. We are a reflection of each other when we misbehave, and it needs to be taken seriously. And my second point, we need to be sensitive as to how to address the absence of civility, what to do about it, how to address it, and what role, if any, our courts will play in managing it in the future. Currently, there's a commission under the guidance of the State Bar and the Supreme Court that is following up on the professionalism guidelines and addressing future strategies and the like for improving civility and professionalism. We should all stay tuned to this because the outcome of that work is important and needs to be recognized, accepted, and adopted by all the members of the bar in the state of Michigan. Let me conclude, though, this section of my remarks regarding this notion of governing principles. I don't think this is very complicated. I don't think the rules that we spend time reading that have been adopted by thoughtful courts is fully the answer. I think we have to ask ourselves a fundamental question. Do we treat each other as we would want to be treated ourselves? Again, not complex, not profoundly deep, a simple question. Are we exhibiting a level of civility and professionalism consistent with how we want to be treated ourselves? And if the answer is, I'm doing something that I would never want somebody to do to me, you've got the gist of it. It's probably that simple, again, because we're lawyers and we spend time drafting lengthy documents. And you'll find that in both the Eastern District and the Western District civility standards. We perhaps overstate it. Whether we overstate it or not, the goal is simple. We would urge you as lawyers to think through the principles which govern you and reflect it in your day-to-day practice. So that's point number one, the principles. My second point is about structure. And you may say to me, what does structure have to do with a discussion about civility and professionalism? Well, what I'm getting at is as we structure our lives as attorneys, we have to start accounting for certain situations, the structure of our work, what it is we do, particularly as trial lawyers or lawyers engaged in negotiations, whether it's contracts, labor, commercial dealings, whether it's domestic relations and dealing with the separation of a married couple and the custody of their children. The areas of our practice have specific structures in them, and I think we need to be mindful of those structures. So let me give you some examples. In a typical litigated matter, we now face issues regarding disclosures and initial conferences with the court. These can, in many instances, be routine events that do not inspire a lack of civility or a lack of professionalism. But in this pandemic era, I've seen more and more evidence of disputes arising that just seem unnecessary, particularly if we were seeing each other up close and personal. Perhaps we wouldn't shift gears into uncivil remarks or fights that didn't need to occur. So as you start your litigation life with conferences with the court, it's worthwhile to structure how you're going to approach civility and professionalism. Do you confer in advance of the court conference as to what it is you're going to achieve? If you have problems with your disclosures, do you go to opposing counsel and say, the time limits we have aren't going to be workable and we're going to need a little bit more time? Or alternatively, you get such a call. The opposing counsel says, I know I have deadlines, but I'm trying to organize. I'm a defendant. I didn't get advance notice of everything in the life of this case that you, a plaintiff's attorney, may have gotten as you prepared for over a year to file your complaint and the like. I'm playing catch up. I need a break. Are you willing to give that break? Are you willing to accommodate a legitimate professional need for an accommodation regarding dates? These are things you should think through as a structural matter in how you deal with your practice. I've given you an example of remarks regarding a deposition setting where an inappropriate and denigrating series of remarks were made to opposing counsel. Let's just talk basically for a few minutes. As you prepare for discovery depositions or debene essay depositions, structurally, what do you have in mind? Are you going to have a series of form and foundation objections as your routine way of disrupting a cross-examination? Are you going to instead say, are all objections preserved? Are we clear that I don't need to object to every single question on form and foundation, that they're all understood to be present, preserved, and that's unnecessary for me to recite them? These are structural things that you can think of in advance before you actually go into a deposition setting. We also have great disputes now about talking objections. And frankly, this has been going on for decades, but it's amplified in the Zoom world of pandemic discovery. And there are more and more examples of it, at least crossing my desk, where the fight over talking objections is very evident. Now, I'm not going to dismiss the fact that at some points in time, there's merit to certain objections and the discussion that goes with it. But to me, this is a structural issue. What's going to be my practice? How am I going to handle it? I'm going to have to anticipate it as I move into settings where questions are asked, inappropriate answers are given. The discussion then takes a detour as to what to do, how to do it, etc. And these can become both difficult and unpleasant. But I think structurally, you need to think through how you're going to address these kinds of issues and address them in advance. And if you have problematic relationships with a particular attorney, and I know it occurs, and I know of individuals who routinely prompt problems or difficulties in discovery activities, you still need to plan structurally what your responses are going to be. You may not change your opponent, but can you navigate our civility codes, our needs for professionalism, and address the discovery issues in real time in a confident, accurate, but collegial way. That's how you're going to be viewed if it's ever raised as a question. And you should think through structurally how you're going to address it. Well, let me move on, because the structural issue applies in other settings. Assume you're in a court hearing or court proceeding. As a proceeding gets underway, issues are almost certain to arise. And let's say we have three key players. We have a judge, we have a plaintiff lawyer, and we have a defense lawyer. Now, I have not made remarks about the judiciary. There are times, however, when even judges lose their temper or their cool. So we have a setting where a tense matter is before the court, and we have three individuals who need to be governed by civility and professionalism. Well, the issue is almost inevitably going to rise in the first instance from a party with a grievance, whether it's in the nature of motion practice and an issue that they want addressed, or it's the response to a motion that's pending, or a remark that inspires a judge to say, wait a minute, you're out of line. And in any of these settings, tempers can ensue. So structurally, we have three individuals who should be structuring how they're going to handle these proceedings. Thinking in advance, what am I going to do? How am I going to address this? I can anticipate from time to time that awkward, difficult things will occur, that tensions may rise, that anger may be evident, that inappropriate remarks will be introduced. All three members of the legal profession, in my opinion, need to have structured in advance how they want to advocate and or address issues, how they want to respond to others who disagree with them, and finally, how they're going to address the attorneys before them as they invite responses that may trigger further tension, difficulties, or perhaps anger. All of us in these settings are representatives of the legal profession, and our proceedings, whether it's trials, arbitration, motion practice, are invitations for advocacy to move beyond that which is appropriate to that which is just frankly wrong. So as you evaluate your practice or your role in the legal process, think through this question of structure. We've already talked about the principles. Those are clear and unambiguous if you read them. But the issue is, what does that mean to you, your clients, your role with the judiciary? Think through this. Make sure you have structured yourself to know how to deal with things in advance. In other words, the principles that we've talked about, the principles that are enumerated in various court documents that are available to all concerned, how does one structure oneself to deal with them? So that's my second principle, is considering issues in terms of structure as one prepares oneself. The final area that I'm going to talk about is application. And again, you may say, what do you mean, Bob, when you're talking about application? That seems sort of abstract. It might seem off the wall. We're not talking about a construction project, or we're not talking about other examples of advocacy. But yes, we are. We're talking about the actual application of civility and professionalism to your work. And let me be more specific. The one thing we're all concerned about in the legal work we do is outcomes. We are not hired by our clients to do anything more or less than achieve a desired outcome. That's the goal or objective of those who entrust us with their issues or problems. And as we go to represent them, we have to be sensitive to the outcomes they seek. Now, in some instances, this is simple. They want a contract drafted with a difficult opposing party, or they want to end a marital relationship of many years with significant assets and children involved. Or perhaps they have a commercial dispute that is being litigated, or personal injuries which result in general liability or medical negligence or product liability claims. Perhaps it's an employment relationship that has encountered difficulties. It doesn't really matter. Any of the illustrations that you want to talk about, the principles apply, they're structured that you need to have, but you must be sensitive to how these principles and the structure of your practice apply to outcomes. Think this through. Let's assume you're taking a deposition and you are losing your temper, you're becoming a bully, you're evidencing a lack of collegiality. What effect does that have on the outcome? Now, you might argue that there are instances when the bully does well by bullying a witness in the questions that are asked and the demands that are made regarding answers. But frankly, I'm willing to bet that those who demonstrate respect, a measure of personality, that can ask a question, you're more likely to get favorable answers as you take a deposition that's designed to generate outcomes. You need to think through what's the best way to get where I want to go. And I'm certain that in most instances, those who are the most professional and the most collegial and the most trusted, more often than not, get better outcomes. Let's apply the same thing to the contract negotiation. In the settings in which I have been involved, where parties are presented with complex difficulties, trust and respect become critical to resolving the underlying problems. Anger, tension, lack of trust, inappropriate behavior, these things do not inspire the process by which outcomes are attained. They don't generate the kind of momentum that's necessary to conclude the matter to which our clients have asked us to address. If we miss out on this and don't understand that there are consequences that can and will emerge from not getting a desired outcome, the post-mortem for failure is what happened. Why did it go wrong? Why didn't we find a solution? And if it's because of poor behavior or a lack of trust or respect among the attorneys, or something which violates those principles that we talked about earlier, there's potential consequences to the lawyer for that, because it sidetracked the basis for the legal representation in the first place. It complicated an already pre-existing complicated problem and took you down a road that obscured the outcome that was sought. So when I speak to you today about application, what I'm really getting at is, as you apply the legal principles that we are to follow, and you have structured yourself so that when you are presented with difficult situations, you can address them, you have the potential to reach an outcome, hopefully in an expedited way. And even if not expedited, in a way that meets the goals and objectives that you were asked to meet. Now, that's the essence of today's remarks, asking you to do something you probably don't ordinarily do as you're called upon to think about civility and professionalism. And what I'm urging is take a moment, reflect, analyze and evaluate how you approach your work, and look at the principles. For most of you, they're probably simply a refresher, things that you probably already knew, but worth reviewing and understanding, because I know a lot of lawyers that don't understand those governing principles. At least they don't understand that they're written and out there to potentially be enforced. As I've said, I urge you to move beyond the principles and to think through how you organize yourself, structure, my word, but prepare yourself for using those principles, or heaven forbid, not abiding by those principles, but structuring yourself in the body of your work for how to deal with them. But most important, I urge you to pause and reflect about the outcomes you get, because after all, that's why we're lawyers, and that's why we do what we do. And in an honorable profession, I think those who do these things best, more often than not, are likely to get the best outcomes. So that probably sounds terribly preachy. I don't mean to be that way, but I am with a body of lawyers in various organizations who have become extraordinarily concerned about these issues. And momentum is building for additional changes in the profession to reflect these concerns over emerging incivility, a lack of decorum, a lack of respect. And this is not what we want in our profession. Whether you've been around as long as I have and qualify as, in effect, an old fart, or you're brand new and just getting started, probably doesn't matter the difference. We're all in this together, and at various levels of professional experience, we encounter these issues, and how we manage them will be a key reflection on ourselves, our colleagues, and most important, to the rest of the world who already thinks that lawyers aren't necessarily the best thing in the world, and that going to a dentist is preferable than seeing a lawyer. Again, not to demean dentists, but you get my point. We sometimes don't rank in the hierarchy of the most respected individuals in the professional lives that some individuals have. With those remarks, I'm more than willing to address questions, comments, concerns, or anything that this group might have. Brandon, I'll put it over to you if there are any questions.
I was going to say thank you, Bob, for your insights today. I'm sure we have tons of questions that could be answered. If anyone has questions, please use the chat feature or the Q&A feature on Zoom. So far, I'm seeing none, Bob.
Well, silence is either golden or a classic reaction to the lecture that might have rang a bit too long and a bit too difficult to track. So if that's the case, I apologize, but would welcome whatever questions, comments you either have today or at any time. Be glad to address them.
So we just got one pulled up, Bob. This one asks, any suggestions on becoming more introspective?
That's a really good question. I shared the incident where I lost my cool, and then immediate aftermath that felt genuinely terrible. I would not urge you to become introspective after you've screwed up. that's a natural and logical time to do that. I think the time for introspection is when you review the principles that have been enunciated and start applying them to what you do in your practice. So what I would urge is simply to take what we talked about here today, and as you think about what it is I do every day, and am I doing it the right way or the wrong way, introspection should become an integral part of that.
New question, Bob. How would you suggest responding to an opposing counsel who has an outburst like ones you have seen?
That's a really good question. Here's my advice, and I'm going to recognize immediately its limitations. There are some acts of behavior that are so outrageous that they deserve one of two reactions. If it is a litigated matter, I think the court should be asked to address it. If you suggest that someone is an ugly pig and do so in a demeaning manner, I think there are consequences for that. And I don't think a jurist should accept that as routine behavior, and that sanctions might be appropriate after a full and fair evaluation of what occurred. I know it's difficult to want to prosecute a matter like that, but I think it deserves attention and would hopefully gain some review by a judge so that that can be dealt with. I don't think we should tolerate it. An alternative exists in cases that don't have a judge available to address such matters, and that's the Attorney Grievance Commission. I think they have a responsibility as well to address matters like this, and particularly in the case of profound and regular or recurring acts of unprofessionalism and lack of civility that can be documented. I'm familiar with some instances of both matters that have been taken to judges and matters that have been taken to the Attorney Grievance Commission. I can't say I was real enthused with the reactions in the instances in which I'm aware of. I am told anecdotally of a couple of incidents that I don't know about, but the description to me says that sanctions were initiated in both instances, one through a judicial ruling that imposed financial penalties and a fine, and in an AGC reprimand regarding inappropriate behavior. So again, they're seemingly extreme remedies, but I think that's what we're left with at the time. And I hope that as this commission that is looking at these issues further will help to foster further interest in taking corrective action for those who merit it.
That seemed to have spurred more questions, Bob. How do you deal with an opposing counsel in a pre-suit matter that doesn't embrace the fundamental principles of civility and professionalism?
In the absence of litigation with an assigned court, the only alternative at that level is the Attorney Grievance Commission.
This one is aimed towards younger attorneys in particular. How do you suggest that younger attorneys deal with opposing counsel who are more seasoned or older and seem to display a lack of civility towards younger attorneys?
That's a very good question. All right, so I have a war story. A senior attorney to me told me that I was guilty after a presentation to our respective clients about the case. He told me in front of everybody that I was guilty of mental masturbation. And I was mortified and I had no idea what to do. Totally baffled. I was embarrassed that I was belittled in front of a lot of people. I was chagrined because I had no idea what to say in response. And I did not seek a remedy. Knowing what I know now, I would have addressed it with the court. And it has context to it that goes beyond the remark. And that context would be useful. But the point was, why was this lawyer, quite senior to me, embarrassing me in an uncalled for way? You could certainly say, hey, Bob, nice try. I disagree with you. I don't think you've got the facts right. You don't have the law right, etc. But to take it down the road that he did stuck with me. And here I am, after probably 37 to 38 years later, I haven't forgotten the individual or the remark. So yeah, it stuck with me and still does. So I should have addressed it at the time. I should have taken it up with the senior membership of my then law firm. I should have done something, but I'm willing to bet at that time in my career, they'd have told me to ignore it, just move on, toughen up, Bob, you're going to hear that kind of stuff, and ignore it. Well, now I'm thinking differently. Our young lawyers need to learn the rules. They need to follow guidance and direction that points to professionalism, and to ignore it is a problem. And we're just going to create by example a litany of young lawyers who are being taught that this is okay. And that's a problem, particularly in this pandemic world where we're tolerating all sorts of inappropriate behavior. So my advice, take it up within the firm, but take it up with the court as well.
So that's the end of the questions. Any other questions for Bob while we have him?
Well, let me conclude, Brandon, by thanks. As I've grown in experience and time, I've come to love the profession. It means the world to me. So my remarks, frankly, are about the future of the profession, not about me and not about my peers. It's really about those who are coming up next. I'm concerned and worried about the next generation of lawyers. I'm concerned that examples are poor, that illustrations of bad behavior are accepted. And I'm hoping for the best, that our profession can mean as much to you as it means to me, and that for the most part, the good 90+% of lawyers who are out there who do the right thing can be our role models, as opposed to those who are, frankly, stinkers. So thank you very much.
All right, and with that, the seminar will conclude. This has been recorded. If anyone would like to access it later, or feel that somebody needs a lesson on civility who couldn't attend, feel free to reach out and you should be able to get a copy.